नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
I don't know, something which is considered as very technical aspect of private international law. I don't know how many of you have heard of Renvoy. Have you heard of Renvoy before? You can hear me, right? No, you can't? Yes, no. Hi, good afternoon. Can you hear me? Okay.
Yes, sir.
Okay, thank you, Shubham. Thank you so much. No, you need to tell me. I mean, in classrooms, even though I know that many of you are not hearing me, that's perfectly fine. At least you are sitting before me. Here the danger is that because of something, I mean, even that bit of connection which we presume might not be there. Already struggling with this. I mean, I was telling someone yesterday that, if this is going to continue for long, and many of my friends who literally wanted to get into academics, many of us might reconsider academics as a profession if this online teaching continues. Not that, of course, we don't have a choice, but I hope it is temporary and we go back to classroom teaching, something which we enjoy, because talking to a machine for long is it's not easy. Yeah, it's difficult. All right, we start now. If any of you have heard of something called a Renvoy, you have not, or you have? No, yes? ये दो ही आंसर हो सकता है, हाँ या ना। ये तो बहुत सिंपल सी चीज है। तो आप बताइए, आपने कभी सुना है रेनवॉय के बारे में इससे पहले? I'm looking for a partner basically who can help me in explaining Renvoy. I remember taking this lecture last semester with your seniors, and literally we asked almost everyone in the class to explain what Renvoy is, because it is generally considered as a bit technical aspect of private international law, not that other aspects are not technical. So just to make sure that everybody has understood it, we asked quite a few people to maybe come forward and explain it with chalks and try to put things how they are placed. Maybe I'll try to explain it here, and let's see how it actually turns out. Now, what we are talking about, or what we talked about yesterday rather, was this concept of incidental question. The day before we talked about classification. Now, with classification, we started with the second stage of private international law, and how once jurisdiction is established, then what is the next step for the courts to do? Now, as most of you would put it, the courts are supposed to identify the law which would apply in a dispute involving foreign element. Now, the problem with or the fundamental issue with private international law is the fact that there is a possibility of application of foreign law as well. Therefore, court will have to identify which law would actually apply. Now, in that sense, court would classify the issue first, meaning thereby that court will have to first understand what is the nature of the dispute. Now, if it is a contractual dispute, then of course, private international law rules relating to contract should apply. Or if it is a matrimonial dispute, then private international law rules in relation to matrimonial issues should apply. Court will then go to the private international law rules and say that, okay, fine. Private international law rule says that in relation to matrimonial question or such, or a particular issue, what would happen is that the law of the domicile state should apply. In that sense, the courts would refer to the law of the domicile state. If it is the same state where the court is placed, then it is fairly easier to apply the law of its own country and solve the dispute. But if the law of domicile is something else, then basically you will have to identify the foreign law and apply it in the given case to solve the dispute. Now, we saw how classification turns out to be a very important factor in deciding the matter at hand. Now, after that, and in so doing, we also focused on Maltese marriage case to demonstrate as to how the problems relating to classification might arise. And yesterday, we talked about incidental question. This is a very, very interesting phenomenon, something which we talked about, and there were too many questions. When we are talking about when we actually refer to incidental question, what we really mean is that in a private international law dispute, there might be a main issue, but at the same time, there might be an incidental or a subsidiary question so closely connected to the main question at hand that unless you decide the incidental question, it would become impossible for you to decide the main question. The examples which we saw yesterday was that a woman has filed a suit with regard to succession to property. And there is a counter argument that, you know what, she was not validly married to the husband whose property she is claiming. Now, why she was not validly married to the women or to the husband whose property she is claiming is because one of the essential criteria of marriage was not satisfied. Now, here the question of succession to property is so intrinsically connected to an incidental question or a subsidiary question that unless you decide the first, you cannot decide the second. That is what we discussed yesterday. And we saw as to how there are larger discussions with regard to what would apply and what would not apply. Specifically, yesterday we talked about two cases, Lawrence versus Lawrence and Schwebel versus Ungar. And we saw that there are different approaches to it. And it is difficult to find out one final affirmative or conclusive position in that regard. I think Cheshire seems to be making an observation that the majority of the decisions in which, say, an incidental question is involved, what courts have applied is the law applicable to the main issue. So the law which has applied to the main issue, in the example which we took today at the beginning of the lecture, of someone claiming succession to property, but at the same time this dispute involves validity of marriage. Now, the law which would apply to the main issue, that is succession to property, the same law would apply to decide the incidental question. That is a trend. That is a general trend, and in majority of the decisions, that is how courts have dealt with that. Although courts have hardly made a strict distinction between the incidental question and the main question at hand in most of the cases. Now, this brings me to this concept which is generally considered as a very, very tricky and I would say a very technical issue, and that is known as renvoi. What do we mean by renvoi? And I would like you to pay attention for the next 30 to 40 minutes, mainly because it is technical. And if you don't understand, just interrupt me and ask. Don't wait for anything else. I mean, you can go and read, certainly. There is no prohibition, but it's better if you have clarity on the basics, which we are going to cover now. So feel free to interrupt me and ask in between. Now, as we have seen that in terms of different stages of private international law dispute, first is that court has to satisfy itself about jurisdiction. The second is that to identify the applicable law. Now, in terms of identifying the applicable law, what we have seen is the classification, meaning that what private international law rule should apply. And that can only happen when we identify the nature of the dispute itself. Now, if, say, the applicable law is the law of the forum, then it is fairly easier. To give an example, a dispute comes before an Indian court. An Indian court is satisfied about the jurisdiction. The dispute involves a foreign element. And court has characterized the entire dispute, say, as a matrimonial matter and say that, okay, now let's use the private international law rules relating to matrimonial issues. And by applying the private international law rules relating to matrimonial matters, court says that, you know what, the law of the domicile of husband and wife at the time of marriage should decide the issue at hand. Now, court will say that what was the domicile of these individuals when they got married? This is, okay, the domicile seems to be India itself. If it is India, it is fairly easier to pick up Indian law despite the fact that the dispute at hand might involve foreign element and say solve the issue. So if it is Indian law which applies after identifying the applicable law using private international law rules, then it is fairly easier. But the real difficulty arises when there is a possibility of foreign law applying to the dispute at hand. What if, after applying private international law rules, court recognizes that yes, law of domicile of husband and wife should be used to determine, or should be used to determine the law which would apply in this case. And court comes out with this fact that, you know what, or court identifies this fact that their domicile was that of Brazil and not India when they got married. And then in that case, court will have to apply Brazilian law to solve the dispute at hand. Now here comes the issue of renvoi. Now you'll have to understand this point, that when court, after classifying the dispute at hand, after looking at the private international law rules of the forum, considers that yes, law of the foreign country would apply at a dispute or in a dispute having foreign element, then we need to identify that foreign law. But when we are saying foreign law, what is the meaning of law in foreign law? What do we mean by law here? This is the genesis of doctrine of renvoi. This is the starting point of doctrine of renvoi. Have you understood this point? At least what I have said. These are very simple points, and most of them repetition of what we have already done. But have you understood this particular point? That the aspect where doctrine of renvoi creeps into a private international law dispute. ये बात समझ में आई आप सबको?
Sir, isn't it the definition of private international law only that you just referred to? I mean, what is the exact difference between that definition and the doctrine of renvoi that you referred to?
Sorry, can you come again?
Sir, we studied as a definition of private international law this only, that whenever a foreign element is involved and the foreign law has to be considered, it has to be used for the purpose of adjudication of a municipal court.
Yeah.
That entails private international law
rules.
And renvoi, and doctrine of renvoi also refers to the same thing only. This is
Manu, I have not defined doctrine of renvoi as of now. Thank you so much for asking that question for clarity. I have not defined doctrine of renvoi now. I'm just preparing a background as to when doctrine of renvoi or how doctrine of renvoi might become or might get into a dispute, or might become as part of a dispute, or might become an important factor as part of the dispute. So we are not really we have not defined doctrine of renvoi as of now. This is not an attempt in definition. It's just an attempt in explaining how doctrine of renvoi might become an important factor in deciding a dispute. Manu?
Yes, sir.
Yeah. Fine. I presume things are fine as of now. Now, I will give you an example to illustrate the point which I'm trying to make. But before that, let me make a very, very simple argument that Indian courts have not recognized renvoi. So whatever we are studying is a doctrine which is recognized in some jurisdictions only to a limited extent. But it is such an important part of private international law dispute that we cannot miss this particular doctrine. Generally, it is considered as one of the most important and fascinating areas of private international law. But let's be clear that Indian courts have not recognized renvoi. Now the example. Now imagine that there is a person called X who is an Indian subject. Now he dies interstate. But when he died interstate, he was domiciled in, say, Italy. And an Indian court basically is required to decide how his movables in India are to be distributed. Maybe to simplify or to put the facts in more simple ways, X, an Indian citizen, dying interstate, domiciled in Italy, left some movable property in India, and then now what Indian court is required to decide is say how his movables in India are to be distributed. Now that is how it is. Now, how will we go about it? The first step, of course, is jurisdiction. That's fine. Jurisdiction part is satisfied. The second step is, of course, the way we have learned about private international law dispute is to identify the applicable law, the law which will apply in the dispute at hand. Now, court will classify the issue. Court will say that fine, it deals with such and such, particularly deals with succession to movable property. Then court will go to Indian rules of private international law, the rules of private international law which applies in India with regard to the subject matter at hand, that is succession to movable property. Now, court would say that it looks like that the succession to movable property is governed by law of domicile. So, Indian private international law rules identifies the law of the domicile as the applicable law when it comes to succession to movable property. Now, what is the law of the domicile in this country, in this case at hand we are looking at? Anyone? What is the law of domicile? What is the law of domicile? I just explained the facts. I mean, are the facts clear to you? देखिए बहुत मुश्किल हो जाएगा मेरे लिए भी और मेरे लिए ज़्यादा because I will keep on thinking about it. An Indian subject domiciled in Italy. Where is the problem? Please tell me.
So the law of Italy is the law of the domicile.
Yes, thank you so much. At least tell me. I mean, that would be good. At least I would know that you are following the discussion. So the Italian law in this case, as being the law of, say, the law of excess domicile at the time of death, will be the applicable law. Now, when we are saying that Italian law, are we referring to Italian internal law or also the private international law rules of Italy? This is where renvoi is very, very important. When we are talking about the fact that law of Italy might apply to solve the question at hand, that is the succession to movable property, what is it that we are referring to? Are we only referring to the internal law of Italy, meaning thereby that how the substantive law is placed, or are we also referring to the private international law rules of Italy? Because if we are referring to private international law rules of Italy, that would mean that we will have to first examine how private international law rule in relation to movable to succession property is placed. And then only we can say that, okay, fine, it looks like Italian private international law rule also refers to say the law of domicile in terms of deciding the issue of movable property, and therefore we can solve the dispute at hand by applying the Italian law. But what if Italian private international law rules says that law of nationality should apply to decide the question of succession of property? This is the technicality we are dealing with. This is the technicality we are dealing with. Are you getting it? ये बात समझ में आई आपको? ये जो मैंने अभी प्रॉब्लम बताया है.
So when we refer to Italian rules on private international law or Indian rules on private international law, is there any document in specific that we are referring to, or
yes,
where do we find these from?
Yeah, I think in the one of our first lectures we made a distinction between how substantive laws are distinct from how these private international rules are placed. And throughout these modules which we have, when we say proper law of contract, matrimonial matters, tortious matters, this is precisely what we are going to talk about. Private international law rules in relation to matrimonial matters. Private international law rules in relation to contractual matters or in matters relating to tort. These rules are part of your legislation itself or common law practice. So your specific legislation basically has certain provisions which will talk about the fact whether law of domicile would apply or some other laws would apply. When it comes to succession to property, whether domicile would apply or law of nationality should apply. So your legislations, your specific laws would itself identify some of these rules which we are talking about. So private international rules are very much part of your own body of law. Every country in this specified statute or laws will have their own rules dealing with private international law. If you remember, in the very first or second lecture, we made a distinction between laws. We say that private international rules are domestic laws. These are not laws which are imposed by some external agencies. Private international law rules are your own domestic law, either codified in your different legislations, or for example, some of them work in accordance with common law practice based on precedents. So yes, these are part of your own domestic laws as distinct from your substantive laws, which would fundamentally determine your rights and obligations. So private international rule with regard to, say, movable property would basically put it as, say, that law of domicile country should apply, or the domicile should apply such and such rules. Especially in matrimonial matters, domicile at the time of marriage would be the deciding law as to whether marriage is valid or not. But what are the principles of validity of marriage? When can it be nullified? These are questions of substance, which is a different law. And that's why, if you remember in the initial lecture, we made a distinction between how internal laws can, or how these laws can be seen as laws which talk about, say, substantive rights and obligation, or many a times we call it as a purely internal law, and private international law rules imbibed in it. So yes, these are domestic laws. These are fundamentally domestic laws. These have nothing to do with, say, how public international rules are placed. That is part of a different legal system, and then it is incorporated within the municipal legal system. That might happen. But these are fundamentally your municipal law, your domestic law of the country. Are you getting it?
Yes, sir. So basically, if using the private international law rules of Indian statute or derived from the precedents of Indian courts or British courts for that matter, which govern our common law principles. So once those rules, if we make out that the lex causae here is the law of Italy, the Italian law. So once we arrive at that decision based on the rules of private international law prevailing in India, so then basically we go ahead and apply the Italian domestic substantive law to the main cause and issue and take a decision. Where is the question of going into the private international law of Italy, sir?
Wonderful. So you have pointed out, you have referred to the question which I just posed. Exactly. Doctrine of Renvoi. Whenever we talk about Renvoi goes beyond applying the purely internal law dealing with the substance. And Renvoi would invoke a situation. It says that no, when we are referring to the law of Italy, we are not only referring to, say, the substantive law of Italy. We are also referring to the private international rules of Italy. And the simple reason for this is that imagine that the Italian court was looking at the same matter. And if Italian court was looking at the same matter, having jurisdiction, it would have applied its own private international law rules to decipher that, law of nationality should apply to decide the dispute at hand. And law of nationality is that of India. And therefore, Indian law should apply to decide the issue at hand. That could be a possibility, isn't it? ये possibility हो सकती है कि नहीं हो सकती है? भाई उसी फैक्ट में अगर इटालियन कोर्ट अगर मैटर को डिसाइड कर रहा है और इटालियन कोर्ट अपने प्राइवेट इंटरनेशनल लॉ रूल्स को अप्लाई करके ये डिसाइड करता है और या ये आइडेंटिफाई करता है कि लॉ ऑफ नेशनैलिटी अप्लाई होगी इस डिस्प्यूट को सॉल्व करने के लिए, तो वो इंडियन लॉ को रेफर कर देगा। जबकि आप इंडियन कोर्ट के पास जब वो मैटर है और ये अगर इंडियन प्राइवेट इंटरनेशनल लॉ रूल ये बोलता है कि आपको अप्लाई करना है लॉ ऑफ डोमिसाइल, तो इंडियन कोर्ट इटालियन लॉ अप्लाई करेगा। एक ही डिस्प्यूट, एक ही सब्जेक्ट मैटर, एक ही पार्टीज के बीच में दो अलग अलग लॉज अप्लाई हो रहे हैं, दो अलग अलग जुरिस्डिक्शन में। प्राइवेट इंटरनेशनल लॉ का तो पूरा पर्पज ही डिफीट हो गया। यहाँ पर हमने इनिशियल क्लासेस में बात तो की है ना कि प्राइवेट इंटरनेशनल लॉ का बेसिस क्या है। The basis of private international law, we said that no, it fundamentally tries to universalize the rights and obligations of parties. So it will say that no, it's not that in relation to the same subject matter you will enjoy different rights and obligations, and in relation to other subject matters you enjoy different rights and obligations. If I am married and I travel to UK for example, और वहां जाकर मुझे बोला जाए कि आप दोनों तो शादीशुदा नहीं है, when I come back to India I am married, तो हमारे पासपोर्ट में एक और लिस्ट हो जाएगा कि कहां कहां आप शादीशुदा हैं और कहां कहां नहीं है, isn't it? So there must be some uniformity in terms of how different legal relationship, different legal rights and obligations are placed. It is this uniformity which private international law seeks to achieve with the help of private international law rules. कि आप उसको ऐसे अप्लाई करें ताकि आप ये एलिमिनेट ना कर दें कि हम तो भाई बस अपना कानून अप्लाई करेंगे, हमें दूसरे कंट्रीज के कानून से लेना देना नहीं। प्राइवेट इंटरनेशनल लॉ रूल और प्राइवेट इंटरनेशनल लॉ बेसिकली क्रिएट्स अ विंडो वेयर देयर इज अ पॉसिबिलिटी ऑफ अप्लाइंग फॉरेन लॉ with an intention to safeguard the interest of the parties, that yes, they have certain rights and obligations and that needs to be respected. They have certain legitimate expectation and that needs to be respected. That is what the purpose of private international law is. We have spent a full week lecture on it. So, are you getting it? Yeah, we are only considering a hypothetical scenario. Now, forget about India. Let's call it as Britain, for example. Let's call it as Britain. Very recently, an argument was made in relation to doctrine of Renvoy. Indian courts rejected it, of course. But what we are trying to understand is the doctrine of Renvoy per se. It is very much part of your syllabus, and Renvoy has been there. So at least few British courts have, or few British judgments have basically invoked invoked Renvoy. In fact, they have gone one step ahead and invoked double Renvoy. So it is for this reason it is important for us to understand that what is this concept called Renvoy and why countries invoke it. One. Secondly, mere fact that other countries can invoke Renvoy, that does not eliminate India altogether just because India cannot invoke Renvoy. Because when it is invoked, it might be invoked in relation to Indian laws. So a foreign country might refer to, say, private international rules of India and then say that whether private international rules of India would, say, apply this law or the other law. So that possibility is there. That's the aspect of private international law we must remember. No country can claim that we are completely independent in terms of applying certain laws, because private international law would fundamentally bring to the picture or would fundamentally bring to the question the application of foreign. That is what I wanted to emphasize on. Donika, is that fine?
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।